it's important to get an attorney involved, if for no other reason than to tell you what the tax implications are, or what they're going to be under various scenarios.
So you talk about a lot of your clients that have real estate in their portfolios. So what if they have multiple real estate assets in their portfolios, not just a homestead or primary residence?
Well, it depends on how it's held. If it's going to make a difference how it's held. If you've got rental properties that are held in your own name, they're going to pass under your will or whatever dispositive provisions you have in a will, a living trust, or even if they pass under the laws of descent and distribution, because there's no other instrument out there to pass them. They're going to pass subject to whatever entity or whoever holds those assets. And by whoever means, is it held in an entity? Is it held outright? Is it held in a partnership where you've got more than one owner? If you're holding investment property in an entity where there's more than one owner and it's not a family member, it is very important that you understand the provisions of the partnership agreement, and if it's a limited liability company, the company agreement. It's very important to understand the provisions of what happens on the death of a partner or a member. Generally, if it's within the family, if we have a husband and wife or a family owning investment real estate, and we've got it in an entity, a limited liability entity of some sort, we generally allow those assets to pass to other family members by just saying, okay, if I have a will or a living trust, my membership interest is going to pass under to the people named in those documents. If you've got third parties who have a joint venture of some type, if you don't have provisions saying what happens at the death of a partner or a member, you may end up, the people who are still living may end up being partners with the spouse or children of their deceased member who do not understand the market and don't understand the investment. And that can be really difficult, especially if you own property that is quite expensive and quite valuable. And it's a large asset, for example, an apartment building. An apartment building or something like that. So you need to be careful about who your partners may be down the line at the death of one of the founders. And it's a very important thing. And I ask people this all the time. We have this discussion all the time is, okay, do you want to be partners with your partner's children or in-laws or whoever, surviving spouse at the death of one of the partners? And it's a very important thing to address when you're initially doing the agreement. It's a very important thing to discuss and know the answer to.
So what if the answer is no, I don't really want to be in that situation? Then what kind of a provision would you have? So
we generally put in provisions in that circumstance for what happens in the event of death, divorce. Because we're in a community property state, if you get divorced and your membership interest or your partnership interest is a community asset, that asset is available to be divided in just an equitable division in a divorce arena. So we generally, and who wants to be partners with their divorce partner's ex-wife or ex-husband? So we usually have a provision for what happens in the event of death, divorce, disability, and disillusionment. So we put all of those provisions in, and they can look very differently. Usually we will have a divorcing member being required to buy out the spouse in the event of a divorce. But what happens in the event of disability? What if you've got people, what if you've got one of the members who's managing an apartment building and that person becomes disabled? So we want to make sure that we've got provisions in there for what happens in the event that person becomes disabled, both with respect to their membership interest or partnership interest, or in the event they are totally disabled and will never be able to come back So we've got
That's
generally
amazing.
got provisions, and it depends on whether or not you have a mandatory buyout of a disabled person or on the death of a member. Depends on what the capitalization is of the business, how much money is available to buy out the estate of a deceased member. Or it may be that those provisions are what triggers you. Oh, we need to go buy an insurance policy on each of the partners or members, and I use those interchangeably. A limited liability company has members, a partnership has partners. Maybe we need to go buy key man insurance so that we've got a pool of money to buy out the estate of a deceased member. So those all come in when you're setting this up at the beginning or inception of the partnership or the LLC. And they're very important things. And these are the reasons why I tell people, yes, you can go and do these on your own. You can certainly go to the Secretary of State's website and fill out the documents and file them with the Secretary of State's office, but that doesn't get you what the agreement looks like. If you don't have your own agreement, then you go under the terms of the Business Organization Code, and those provisions may not be provisions that you want to be governed by.
Right. Yeah. So typically speaking, if you did have, let's say, a partner that was either deceased or disabled, is there generally some sort of a time that's put into these agreements?
Yes. Well, so usually, I mean, there has to be a lag time with respect to death, because you never know how long it's going to take you to find a will, get a will probated, find the living trust. You've got to wait for death certificates to come in, which can take anywhere from 2 weeks to 6 or 8 weeks, depending on how busy the medical examiners are to get to the death certificate. So there's going to be a lag time on whatever you do. Disability, usually we will have a 180-day delay to allow someone to, if it's a short-term disability, but very often the terms of buying out a disabled member would be after 180 days, once it's really determined that the person is fully and completely disabled and is not going to be able to come back.
Okay.
Because we don't want, and you know, there are going to be circumstances when members are going to decide they want to continue to finance, they want this disabled person to continue to get paid, to continue to get their pro rata share of the income. And then there's going to be times where that's not really going to be operable. That's not going to work very well for the ongoing enterprise. So it's really a situation. Disability is really sort of an ongoing, yes, we put provisions in there and you can always fall back, but that's sort of the place where partners will have to work together to determine the best course of action in the event of a disability.
So I'll switch gears with you and do something a little bit not so high level for people that aren't invested in partnerships and in apartment buildings or in their 90s.
Right.
Let's talk about middle age, average, still working folk who probably have some assets. This asset combination would be greater than just their own homestead. So we're talking about probably a partners. They've got their own home and at least one investment property. And let's say they've done no estate planning really whatsoever.
Okay.
Sometimes it can feel like a really big, like, well, how am I going to wrap my head around this? Where should I start?
Absolutely. Well, the place where I start when talking to people about a non-homestead piece of real estate is going to be looking at the composition, the total composition of their assets. If what they have is a rental property, a home, and most of their investments are tied up in a retirement plan, the homestead is going to be exempt from creditors' claims, because that's what Texas property law says. The retirement plan is also exempt from creditors' claims under another provision of the Texas statutes. so that we don't have to be so concerned so the idea is, what do these people have to lose in the event they're sued? And in that particular case, there's a car, maybe there's a bank account that they keep, $25,000 or $50,000 in. There may be 2 cars, a home, a retirement plan, and not much else. Then the concern is the only real thing that's available for a creditor, and a creditor can come from getting hurt on someone's property where they get sued for something beyond what their homeowner's insurance covers for liability, or they're in a car accident where they're at fault and someone is hurt and it's beyond the liability coverage on their insurance. Then if those folks get sued, then that rent home is available to make the judgment creditor whole. So in that instance, we may want to look at wrapping a limited liability shell around that real estate. Here's the questions that I ask. Who are you renting to? If you are renting to, if it's a single family home and you're renting to families, I am a whole lot less concerned about wrapping a limited liability shell around that home, because you can insure around that problem. You can have that home you can have it insured for the maximum amount you can get for a fairly low cost, and make sure that it's going to make anyone who gets harmed or you may hurt outside of the ownership of that home, you have enough insurance to make them whole. If you're renting to college students, or you've got an apartment building or a home near a fraternity house, I'm going to tell you to wrap as many limited liability shells around that as you possibly can, because you can't control the kids jumping off a balcony into the swimming pool when they've had 4 or 5 drinks. And even if it is not your fault, if you're the owner, or even if a limited liability company is the owner, that's who's going to get sued. Now, it may very well be that the lawsuit isn't going to stick, or the lawsuit isn't going to be problematic because the action taken is really what caused the harm, not the fact that you owned the building. But nonetheless, we want to take more precautions if you're renting to college students than we would if you've got a single family home. And I'm not sure if that takes care of your question or not. But that's how I begin to build an estate plan. If you've got someone who owns rental real estate outside of the state of Texas, the first thing stated is going to be, either does the state where you own this property have what's called a transfer on death deed, so that you can ascertain from the beginning to whom that property is going to go at your death, or put that property into a revocable living trust, so that we don't get saddled with a probate in a state other than the state where the decedent resides. So if you live in Texas and you've got a Texas will, that's fine, and you leave your assets to people. But if you own real estate outside of the state of Texas and it just passes under your will, you're going to have a probate outside of the state of Texas. And depending on, Texas is easy with respect to probate law. But if you've got a state like Florida or California, where you've got dependent administration, which means you can't so much as sell that house without approval from the court, it's an expensive endeavor to have to do a probate outside of the state of Texas. So